in? I got a piece of information I want to share with y'all. As we know, today is the day that the Southern District of New York has to file their reply brief in response to the appeal filed by Alexander Shapiro to get Puffy's sentence reversed or vacated to where he would have no conviction at the best, and at the worst, Puff should be brought back to court and resentenced without acquitted conduct. This is public information. You could go online and get this. It's a 22-page document. I just read it. This is a dope piece of information. It's an amicus brief filed by some people that don't have anything to do with Puff. They're not paid. Hold on, y'all. They're not paid. They didn't receive any compensation. Myra, is that you? There go Myra. I see you, Myra. They didn't receive any compensation. They're not making no money. They're just doing this because they see a miscarriage of justice. The judge in Puffy's criminal case, I'm not even going to say his name. I don't even want to say his name and give him no publicity because he was way out of line with this sentence that he gave Puff. And not only did I feel that way, a bunch of people felt that way. We already know this amicus brief is filed by the National Association of Criminal Defense Lawyers. And they say, and they lay out a good argument and a good case based in facts, not on emotion or how you feel or a funny blue jacket Instagram reel or a YouTube post. These are lawyers that are doing their thing, rooted in constitutional law. They say in this document, goddamn Kais JP finna be a doctor. Everybody shout out my man Kais JP. He finna go to, what's up Maria? I see you in Canada. He finna go to medical school. Just got that biology joint. These lawyers say that Puffy's Fifth Amendment, his right to due process clause, was violated with the sentence using acquitted conduct. And they say Puffy's Sixth Amendment right, his right to a trial by jury, was violated by the sentence that was handed down. Myra, thank you for the super chat. You're the best at what you do. Thank you, Myra. California in the building, West Coast locked in. That Puffy's constitutional rights were violated. Alexander Shapiro also goes a step further and says that his First Amendment rights were violated. That he is allowed to film amateur porn. He's allowed to do that. That's his First Amendment right. And that's what he was doing. That he was not engaging in USC 2421, which is transportation of individuals in interstate commerce to engage in selling of the kitty cat. Now, this was a dope-ass document. Amicus Curiae, National Association of Criminal Defense Lawyers, submits the following corporate disclosure statement as required by federal law. The National Association of Criminal Defense Lawyers is a non-profit organization organized under the laws of Washington, D.C. Check me out. Share this video, y'all. Puffin to come home, man. It's over. Page 1 or page 7 of 22. Page 7 of 22. You can get this on Pacer. This is public information. Page 1. You see, I read the whole thing. See, I underlined mine. I ain't like Funny Blue Jacket. The National Association was founded in 1958. It's a nonprofit, voluntary, professional bar association that works on behalf of criminal defense lawyers to ensure justice and due process for those accused of crime or misconduct. It was founded in 1958. My girl Maria up in Canada with the $20 joint, sidebar, up in the overflow, in the back there, in the overflow. The National Association of Criminal Defense Lawyers is a nationwide membership of more than 12,000 and an affiliate membership of almost 40,000. The National Association of Criminal Defense Lawyers members include private criminal defense lawyers, public defenders, military counsel, law professors, and judges. The National Association of Criminal Defense Lawyers has long maintained that the Constitution prohibits consideration of acquitted conduct sentencing. It has taken that position in amicus briefs before federal courts, including McClinton versus United States, and it has done so repeatedly in comments to the Sentencing Commission, most recently in connection with the 2024 Acquitted Conduct Amendment to the Sentencing Guidelines 1B1.3, Section C. The National Association of Criminal Defense Lawyers has decided to submit this amicus brief on behalf of Puffy because the judge's erroneous interpretation of 1B1.3 Section C eviscerates the Acquitted Conduct Amendment, and because the judge's reliance on acquitted conduct under 18 U.S.C. 3553 and 3661 violates the Fifth Amendment right to due process and the Sixth Amendment right to the trial by jury. The judge in Puffy's criminal case committed two critical errors of law in sentencing Puff based on conduct, particularly coercion of his sexual partners, on which the jury had acquitted him of. Now we know that Cassie set up the freak-offs. Jane Doe set up the hotel nights. They did that on their own. Cassie reached out to Clayton Howard. Jane Doe reached out to Cabral. Jane Doe reached out to Antoine. Jane Doe reached out to Don. You understand? Cassie reached out to Jules. They did this on their own. These Cassie reached out to the Punisher. Puffy did not reach out to these dudes. These freak-offs and hotel nights were set up by Jane Doe and Cassie, so there was no coercion. The judge in Puffy's case misinterpreted the Sentencing Commission's 2024 Acquitted Conduct Amendment. That amendment excludes acquitted conduct from the determination of relevant conduct unless the acquitted conduct establishes in whole or in part the instant offense of conviction. The judge in Puffy's criminal case interpreted the key term establishes as a relevancy test. That is wrong for three principal reasons. First, the judge in Puffy's case ignored the plain meaning of establishes, which means to prove, a far more stringent standard than mere relevance. Second, the judge in Puffy's case overlooked that during the Sentencing Commission's consideration of the 2024 amendment, the Department of Justice advocated a relevancy standard. The commission said, nah, never that. The commission told the Department of Justice, never that. That's too loose. We want a tighter joint. The Sentencing Commission rejected the Department of Justice proposal in favor of the establishes requirement. And third, the judge in Puffy's case interpretation violates the rule that the sentencing guidelines, like statutes, must be construed to avoid absurd results. So, the only way coercion and force could have been used to enhance Puffy at the sentencing and enhance his guidelines would have been if force and coercion were used in the Mann Act, which we know they weren't, right? Because Cassie and Jane Doe, they was with it. And coercion and force were predicate offenses under the racketeering conspiracy and also under the trafficking charges. The jury acquitted him of those. Once the jury acquitted him of those, it's over. It's over. You can't use it. The jury said, nah, never that. The jury said no. But the judge used 3553 and 3661, saying that using Puffy's past behavior and all this other nonsense to enhance Puff. They going against that. The judge in Puffy's case erred as well in holding that regardless of 1B1.3, the judge said it was free for him to consider acquitted conduct under 18 U.S.C. 3553 and 3661. The National Association of Criminal Defense Lawyers has long maintained the Fifth Amendment of the Due Process Clause, the Sixth Amendment of the right to a trial by jury to prohibit the use of acquitted conduct to increase a defendant's sentence. A broad range of current and former Supreme Court justices, federal appeals court judges, and district court judges, scholars like Sean G., and legal advocacy organizations from across the political spectrum agree that acquitted conduct sentencing is no good. Argument. The acquitted conduct guideline permits consideration of such conduct only when it proves an element of the offense of conviction, not when it is merely relevant to that offense. During the Sentencing Commission's consideration of the 2024 acquitted conduct guideline, the Department of Justice advocated for an exception that will permit courts to consider acquitted conduct that relates in whole or in part to the instant offense of conviction. The commission said no and rejected that relates to. And instead, it adopted a far more narrower exception, allowing consideration of acquitted conduct only if that conduct establishes in whole or in part the instant offense. So if in order for Puffy to have been enhanced for coercion, enhanced for force, that would have needed to have been proved in the Mann Act joint, which wouldn't have been a USC 2421, it would have been a USC 2422. But that wasn't the case. But Puffy's judge, he wasn't really the judge. He was just a puppet on the string. Somebody told him what to do, my opinion. The district court in Puffy's case applied the very standard that the commission rejected. The judge in Puffy's case held that he could consider acquitted conduct in calculating the guidelines offense level if that conduct was relevant to the offense of conviction. Check me out. We're coming straight from the paperwork. This ain't no Instagram meme from Funny Blue Jacket. Funny blue jacket. Funny blue jacket. Relevance, by contrast, is a far more broader and more elastic concept, as this court has observed. Relevance only requires the evidence to move the inquiry forward to some degree. Second, the Sentencing Commission considered and rejected the government's proposed relates to standard for the use of acquitted conduct. The judge in Puffy's case erred in substituting the government's preferred standard for the more stringent standard than the commission. The United States Sentencing Commission said that you got to be playing all-star game Major League Baseball in order to include acquitted conduct in force. But the Department of Justice said all you need to be playing is Little League Baseball to include it. So it's easier. The government wanted the easier way to let it in. But the commission said, nah, never that. Step your game up. Like Funny Blue Jacket need to step his game up and lose some weight because he got diabetes. Inflammation, man. Third, the district court substitution of is relevant to for establishes violates the rule that courts must avoid absurd interpretations of statutes. Page 6. We locked in. Page 7. The Fifth and Sixth Amendments prohibit consideration of acquitted conduct under 18 U.S.C. 3553 and 3661. The Fifth Amendment due process guarantee and the Sixth Amendment right to a trial by jury means that an acquittal insulates Puffy from punishment based on conduct that the jury at Puffy's case found that the prosecution, the Southern District of New York, Maureen Comey, Christy Slavic, Emily Foster, Smizer, who else was over there on their team? Reddick, that they failed to prove in Puffy's case, most notably coercion. Right there. They got beat. They lost. Southern District of New York lost. The acquitted defendant, Puffy, hold on a second. I got all my shit copied down. As Supreme Court Justice Sotomayor explained, juries are democratic institutions called upon to represent the community as a bulwark between the feds and Puff. And the jury's verdict are the tools by which they do so. An acquitted defendant, Puffy, has been set free or judicially discharged from accusation, released from the charge of suspicion or guilt. There you go. You ain't got to take my word for it. I know you don't believe me. I know you don't like me. I don't like you neither. Tie score, tie game. You don't like me, I don't like you. Even Steven. Punishing Puffy for acquitted conduct undermines Puffy's Sixth Amendment right to a trial by jury. It diminishes the importance of jury service, leaving jurors to wonder if their careful sifting of the charges and evidence is a waste of time. Punishing a defendant for acquitted conduct undermines the Sixth Amendment right to a trial by jury. It deters defendants from exercising their right to a trial by jury because a partial acquittal even on the core of the Southern District of New York's case, does no good. Unless Puffy obtained an acquittal on every single count, unless Puffy pitches a no-hitter, Puffy finds himself punished as if he had been convicted on all the accounts. Chief Justice of the Supreme Court of the United States, Justice Sotomayor, is not alone in doubting the constitutionality of punishing Puffy for conduct on which the jury acquitted him. Supreme Court Justice Scalia, Supreme Court Justice Clarence Thomas, Supreme Court Justice Ruth Bader Ginsburg, Supreme Court Justice Stevens, Supreme Court Justice Kennedy, Supreme Court Justice Gorsuch, Supreme Court Justice Barrett, Supreme Court Justice Kavanaugh have all expressed concerns, or at least acknowledged the constitutional significance of sentences based on acquitted conduct. There it go. There it go. I got it. Page 11. I'm not like you, man. I don't listen to motherfuckers on Instagram and YouTube that wear funny blue jackets. I don't do that. I don't listen to dudes that wear funny blue jackets that got diabetes and inflammation, high blood pressure, cholesterol, and all that. I come with the paperwork, man. I come with the documents. If the Fifth and Sixth Amendments require a jury finding of facts important to the sentencing decision, they surely prohibit increasing Puffy's sentence based on conduct that the jury found the Southern District of New York failed to prove. Damian Williams was the United States Attorney. Damian Williams brought the charges. Remember, he did the big press conference. You understand? Bloodline go back to Jamaica. He ain't no foundational black American. No, he ain't. No, he ain't. No, he ain't. Damian Williams, the United States Attorney in the Southern District of New York that brought the charges against Puff, talking about baby oil this, Astroglide that, baby oil that, Astroglide this, baby oil over there, Astroglide over there, baby oil. The jury said, yo, man, get out of here with that. Step off. The jury says, step off. Because the Southern District of New York failed to prove their case, Puffy must be resentenced. Puffy must be resentenced. Combs must be resentenced. Conclusion. The judge in Puffy's case, reliance on acquitted conduct to increase Puffy's sentence, eviscerates the 2024 acquitted conduct amendment and violates his Fifth and his Sixth Amendment constitutional rights. If the appeals court, the Second Circuit Court of Appeals in New York, declines to reverse the conviction, just reverse the whole thing. This shit is trash. Get it up out of here. If the appeals court declines to reverse the conviction, it should remand Puffy's case for resentencing without consideration of acquitted conduct sentencing. Acquitted conduct either under the guidelines of 3553 or 3661. There it go right there. There it go right there. That's it. That's it. So this is a nonprofit organization based out of Washington, D.C., that is coming to Puffy's aid. Puff ain't paying him. They ain't getting no money from nowhere. They just chilling. The National Association of Criminal Defense Lawyers was chilling over there watching the whole thing. They was watching the whole trial. And they was chilling in the back like, I'm going to see if this judge going to do the right thing. And they busted the judge. They saw what the judge did and said, man, that shit ain't right and exact. No, it ain't. No, it ain't. No, it ain't. And under their own volition, under their own judgment, under their own choices, under their own actions, they chose to get involved and submit this document on behalf of Puff to the Second Circuit Court of Appeals and say, yo, y'all gotta overturn his conviction, man. Let that man go home to his 4 black daughters. That funny blue jacket keep terrorizing on Instagram. If you don't let him go home to his 4 black daughters, you gotta resentence him. He already done did 17 months. 50 months is the longest sentence for the Mann Act with Puffy's circumstances in the history of this case, the Mann Act charge. First offense, no prior criminal history. Got enhanced 13 levels by this judge and got 50 months. 50 months. So you know what it is with me on this channel. It's always free Puff. It's always free Puff. Now, the Southern District of New York has until tonight to submit their reply brief. It's due today. If they don't submit it by today, Puffy go home. But they probably gonna submit it. So as soon as they submit it, I'm gonna get a copy. Alexandra Shapiro says she's gonna send me a copy. Shout out to Alexandra Shapiro. Everybody go buy Alexandra Shapiro book. Go follow her on Instagram. Alexandra Shapiro. She saved Puffy's life. And she continuing to save it. So soon as their brief comes out, I'm gonna get a copy and I'm gonna go live again. Now, once the prosecution submits their reply brief today, then Alexandra Shapiro and them got until March 13th, 3 weeks, to file another brief shooting the brief that the government gonna file today in the head, killing it. Then if the Second Circuit don't overturn it based on that, then we go to oral arguments live in New York City, April the 9th. Be there, be square. Sean G gonna definitely be there. You understand? It's gonna be in Manhattan. It's gonna be in Manhattan. Just make sure you be there. And we're gonna find out, you know, if the prosecution has nothing to stand on, no leg to stand on. The only way, from a legality standpoint, from a procedural standpoint, from a law standpoint, that Puffy's conviction gets stayed and maintained is if the appeals judges are bribed by the government or threatened by the government to not release him based on law. That's the only way. That's the only way. But I don't see that happening. I see the reason that the judge in Puffy's criminal case did what he did, he's the first South Asian judge to be admitted in the Southern District of New York. He's from India. He's not an American citizen. He's an immigrant. His people migrated here. He's got 2 years on the bench. So he nervous and scared as a cat on a hot tin roof. Everybody hit that like button. Put me on 99 likes. Put me on 99 likes. Hurry up. He nervous as a cat on a hot tin roof. He trying to please his bosses, and they telling him what to do. They used, the powers that be used coercion and force to make him sentence Puff to 50 months. That's where the force and coercion was. But these appeal judges are seasoned judges. They've done the district court thing. They're established. They, at this point in their careers, are more concerned with their legacy, their name, their integrity, the esteem that they're looked upon amongst their colleagues. So I don't think they give a fuck what somebody else is going to tell them to do. I think they're going to do what's right, because they know that when people look back on this case, on this appeal, they want the world to know and future generations to know that they got it right. When we look back on this case, when people look back on this case 6 years from now, 16 years from now, 60 years from now, 300 years from now, and they look at the district judge in Puffy's criminal case, they're going to look at his performance and say, this guy got it wrong. And him and his children and everybody related to him going forward are going to be held in low esteem, because they're going to see that he acted outside of what was right. So I think Puffy's sentence is going to get overturned, and at the very minimum, he's going to be let free in April. Sean G, Podcast with Soul. Thank everybody for the super chats. It don't never stop. Peace.